Good morning, everyone. My name is Tiara Yakini, and I work in the Community Engagement and Education Division at the Michigan Department of Civil Rights. I will be your moderator this morning. For full accessibility today, it is critical that speakers first identify themselves by name before proceeding to speak and mute their microphones after they are done speaking. We have ASL interpreters on screen, and live captioning is available by turning on subtitles using the CC icon on the lower part of the screen. We will have a question and answer portion during today's session, and attendees can use the Q&A function on the lower part of the screen to type in questions for our panelists at any time. With that said, it's with great pleasure that I welcome you to the final installment of our 2023 MI, spelled M-I, Response to Hate virtual campaign forums. This year, through our monthly installments, we have explored numerous issues pertaining to hate and bias, beginning with an informative discussion on hate crime reporting. We have also begun to dissect the Elliott Larson Civil Rights Act by highlighting ways that people are protected from hate and bias in areas of employment, education, housing, law enforcement, and public accommodations. The campaign will culminate with our annual My Response to Hate conference scheduled for Thursday, September 14th, which you will hear more about later in the program. For now, please take a look at the PSA that our team developed to capture the spirit of the My Response to Hate campaign.
Did you know that race is the #1 motivating factor for hate crimes in the United States?
Did you know that hate crimes against Asian Americans have increased by over 73% since 2019?
Did you know that there are state and federal laws that protect you against hate crimes and bias incidents?
The Michigan Department of Civil Rights and the Michigan Alliance Against Hate Crimes have launched the My Response to Hate campaign to inform Michiganders of hate crimes and bias incidents occurring in Michigan.
You can take action in your own way by showing love, not hate.
If you see something, say something.
Support victims. Report the incident.
Make a commitment.
My response to hate.
My response to hate.
My response to hate.
My response to hate is love.
Visit michigan.gov/MDCR for more information on hate crimes, bias incidents, and available resources.
So it is our hope that this campaign provides you with information pertaining to hate and bias prevention that you can implement and use in your daily lives, at your businesses, in your schools, and in your communities. Without further ado, we're going to jump right into today's topic. Today, our focus is making Michigan accessible. We have a dynamic panel of presenters lined up for you today who will lead us in exploring how business owners are obligated to provide goods and services that are accessible to all. Our first presenters are from the ADA Compliance Division, housed within the Michigan Department of Civil Rights. This division is tasked with ensuring that executive branch departments within the state of Michigan meet their requirements under the ADA. The division also provides training, resources, and technical assistance internally to MDCR staff, as well as the other two branches of state government and any interested member of the public. Joining us today are two members of the division, Tyra Khan and Anthony Ianni. Please welcome them as they discuss disability law at both the state and federal levels, as well as the use of service animals in places of public accommodation. ADA Compliance, you now have the platform. Welcome.
This is Tyra speaking. Thank you, Tiara, and good morning, everyone. As Tiara said, my name is Tyra Khan. I'm the director of what's called the Disability Rights and Compliance Division that's housed within the Department of Civil Rights, and that makes up several divisions, but for our purposes today, the ones that are important to what we're talking about is ADA Compliance and our division on deaf, blind, hard of hearing. Just before we get started into the weeds here, I'll just read our disclaimer. The information provided in this presentation does not and is not intended to constitute legal advice. All information and content materials used in this training are for informational purposes only and are not a determination of a particular individual's legal rights. So there are two laws that we will talk about today over which our department has jurisdiction and relate specifically to civil rights and disabilities. And it's important that we talk about these things because 1 in 4 individuals in our country report being a person with a disability. Mobility and cognitive impairments are the most common, and over 43% of adults age 65 or older are persons with disabilities. And what we talk about and think is very important is that any one of us at any time in our lives can become a person with a disability. So it's important that we understand our rights as well as obligations as business owners. So the first law that I'm going to talk about, and this is just going to be a brief overview with the time that we have. We don't have enough time to deep dive, but we can always do that at a later date. So the first law is called the Americans with Disabilities Act, and it's shortened. Very often you'll hear it being referred to as the ADA. It was enacted in 1990, and it was amended a few times to broaden the scope of protections after some court cases really restricted the rights of individuals with disabilities. It was really the first comprehensive civil rights law to cover all areas of public life. There are several titles, and I'm just going to briefly touch on them. The first one is Title I, and it covers employment. It applies to employers that have 15 or more employees. It can be a private employer, state or local government, employment agencies, and labor unions. It mandates that no qualified individual with a disability should be discriminated against in any way, and it covers the whole gamut of employment, from hiring, advertising, recruiting, interviewing, and the actual tenure of employment. The second title is Title II, and it covers public services, and that's your state and local government entities like our departments, your DNR, lottery, health and human services, treasury, all of those types of things. And Title II again says that no qualified individual with a disability should be excluded from any state or local government program, service, or activity because of a disability. Then we move on to Title III, which covers what we're really talking about today is what is called public accommodations. And that just means businesses that are open to the public. That includes private businesses and nonprofits. And it says that you cannot just deny a person with a disability the full and equal enjoyment of whatever you're offering. Your goods, services, the facilities that you offer them in, any privileges or advantages of that business. Because they're a person with a disability, or because they may need an accommodation or some type of adaptive device to use your services. And then Title IV talks about, it covers telephone and television access for people with hearing and speech-related disabilities. So in a nutshell, the ADA says that people with disabilities have the same rights and opportunities as those without, and it includes protections against retaliation. As I said, there's a lot to the law, but in general, you cannot overall discriminate against people with disabilities. Another aspect is that you may have to provide accommodations or modifications. Those two words are used interchangeably, and it just means a change to the way things are normally done. You may have a policy, practice, or procedure that with which you conduct your business. You may have to change that slightly to afford people with disabilities to use your services. You may have to provide what's called effective communication. And that's the tenet says that communication between people with disabilities and those without has to be as effective as communication with when you have people without disabilities. So this may require you providing what's called an auxiliary aid or service. And you can see today we have CART or captioning services, and then we have American Sign Language services, which allow people with those types of speech or hearing related disabilities to be able to participate. And then finally, program access. Program access says that any service that you provide has to be provided in the most integrated setting. This applies to web-based programs and services, which our colleague in the digital field, Phil Deaton, will talk about later. It also applies to those architectural or building standards in new construction, and then alteration of existing buildings. And then finally, relocation of programs and services that are being held in inaccessible or older buildings to places that allow people with disabilities to go. We have a state law in Michigan that mirrors, in most respects, the ADA. It, in a nutshell, again, requires that a person, and that means a business owner has to accommodate a person with a disability unless doing so would result in an undue burden. And this again prohibits retaliation against an individual for exercising any of their rights under state or federal law. So that takes us, as I said, a very brief definition of the laws that we enforce. I am going to turn it over now to my colleague, Anthony Ianni, to take us into what we will be talking about next, which is our service animal program.
Thank you, Tyra. Good morning, everybody. So we'll get right into it here. A service animal definition. So a service animal is a dog or miniature horse individually trained in work or a task that mitigates their handler's disability. The animal's work or task must be directly related to the handler's disability. There are no breed restrictions for service dogs, and service animals are trained disability aids. They are not pets. So miniature horses. So for service animals, there are two types of service animals. You could do dogs or miniature horses. So for miniature horses, the ADA includes 4 assessment factors to help determine whether a miniature horse can be accommodated by a facility. Number 1, the type, size, and weight of the miniature horse and whether the facility can accommodate these features. 2, whether the handler has sufficient control of the miniature horse. 3, whether the miniature horse is housebroken. And finally, whether the miniature horse's presence in a specific facility compromises legitimate safety requirements that are necessary for a safe operation. And just some information here about miniature horses as service animals. Normally between 24 and 34 inches in shoulder height, and they weigh around 70 to 100 pounds. They are the ideal size for mobility assistance. They can live much longer than dogs, up to 35 years in age. Training is more extensive than for service dogs. Miniature horses are more allergen friendly than dogs. They are often less social or easily distracted than dogs. And law allows for a second option because some religious beliefs do not allow interactions with dogs.
Okay, this is Tyra speaking again. So as Anthony just gave us that brief definition of what a service animal is, just so everyone's on the same page, businesses that are open to the public under state and federal law have to allow service animals into places of public accommodation. There is a new law that was passed in Michigan last year. It differs from the ADA in that it says that you have to allow service animals in training into your place of business. So people with disabilities have the right to train their own animals under the ADA. That's a big misconception, is that a lot of people think that service animals have to be trained by a specific facility or undergo certain criteria of training, which is not true. Individuals, again, can train their own animals, or they can use those methods of professional training or organization if they choose. Service animals in training are not covered under the ADA until their disability related task training is complete. Again, this is a change. The new law passed last year. It only applies in our state. Other states may have that, but we tell people this is a Michigan law. And it requires service animals in training to be admitted if they're accompanied by their trainer or an animal raiser for the purpose of training that animal to perform a work or service task, or for behavioral socialization. So there's 2 kind of areas that a person can bring a service animal in training in to teach them how to do those specific worker tasks, and then just for that general socialization. Our department, the Department of Civil Rights, does not have jurisdiction over this law. We don't take complaints on it. If someone has an issue or concern, it is codified under the penal code. And so local law enforcement has jurisdiction over that. So if you ever had concerns over this law, you would contact your local law enforcement agency. Just to give you some kind of idea about what are some of the tasks that service animals perform. This is not by any means an exhaustive list, because just as there are many disabilities out there, there are many tasks or work that animals can be trained to do, but these are some of the most common. Assisting individuals who are blind or who have low vision, alerting individuals who are deaf or hard of hearing to sound or noises, retrieving items such as medication, telephone, water, alerting to oncoming seizures. There are also animals that can alert to latex in the environment, peanuts in the environment for folks who have peanut allergies. They can be specifically trained to do that. The animals can be trained to prevent or interrupt impulsive or destructive behaviors for people who may have some psychological issues and self-harming. And they can also provide physical support or assistance. Dogs, especially larger dogs, and those miniature horses that we talked about can be very good for gait or balance stability for individuals who have those types of disabilities. Very important to know that service animal tasks do not include things like emotional comfort or support, general companionship, violent protection work, or crime deterrence. A word about psychiatric service animals. The ADA does make a distinction between psychiatric service animals and what I just talked about, emotional support or comfort animals. If a dog has been trained to sense that an anxiety attack is about to happen and to take specific action to help the owner to avoid those attacks or lessen the impact of those attacks, that animal would qualify for a service animal. But if it's an instance where the dog's mere presence provides comfort or support, that would not be a service animal, because we go back again to the definition of a service animal, which says that that individual dog has to be trained to do work or perform specific tasks. So service animals can be helpful with people who have different types of psychiatric disabilities. There are some examples here: post-traumatic stress disorder, anxiety, or depression. Some of the tasks that we've seen psychiatric service animals perform are assisting in a medical crisis, again, retrieving that medication, leaving the handler and going to get help, opening doors, carrying notes, that physical support that I mentioned earlier. They can also wake a person up from night terrors, alert to, again, sounds or doorbells, fire alarms. They help individuals cope with a sensory overload by providing tactile stimulation. And what that means is the animal actually put their paws on the person's body and apply pressure. They can find an exit for a person when it's a crowded room. They go in before the person and kind of sweep or clear the room, and they can arouse a person from disassociation. They can peek around corners, turn on lights. There's lots of things these animals can be trained to do. There are other assistance animals out there. They're not service animals, but we think it's important that you know the distinction and the difference. There are different categories. So we have those service animals that we talked about. It's only a dog or a miniature horse, work or task related. Some animals are called emotional support animals. And as I said, they're only there to provide that comfort and support. And there's no disability task related training. They don't do anything really to mitigate their handler's disability. And I know that is a controversial statement because a lot of people, and I understand the importance that dogs can play in a person's life, but unless they're work or task trained, they're not considered service animals, and they do not have to be allowed into places of public accommodation or businesses. They're only covered under what's called the Fair Housing Act, and that applies to rental properties. The next type of animal is called a therapy animal. And those are animals that we see that go into maybe a courtroom setting, a school after a traumatic incident or altercation. They go into hospitals, and what they do is they provide comfort and support to many people, not just one person. And the distinction is that they have to be invited by the facility to come in and do that type of work. So what are some of the questions that covered entities can ask? If in a covered entity, we say a business, you're the business. A business can ask if you're uncertain. So if someone comes into your business and you're not sure that it's not obvious or clear that the animal is a trained service animal, there are two and only two questions that can be asked. One is this a service animal that's required because of your disability? And if the answer is no, you don't have to move forward. You can say it doesn't appear that this animal is a service animal and only service animals are allowed. If the answer is yes, you move on to question number two is what work or task has this animal been individually trained to perform? And that person has to identify the work or task. However, they do not have to disclose details about their condition or even what they've been diagnosed with. The business cannot require someone to ask for training documentation or any medical documentation or quote unquote certification. There is no certification that's recognized under state or federal law. The animal is tied to the training. The legal protections for the animal is tied to their training only. You cannot ask the handler to have their service animal demonstrate the work or task that it performs. And the reason for this is, well, there's many reasons, but most importantly is that that animal is only trained to perform the work or task when it's triggered to do so. So it may not be able to perform on command. And then you can only ask those two questions, but you shouldn't do that if it's apparent that the person is a person with a disability and the animal's task is apparent. And an example would be if someone was maybe in a wheelchair and using a service animal, or if the service animal was leading someone who may have some vision related impairments.
Okay, registration identification through the ADA. So service animal registration is not required under the ADA. Certification, registration, identification, other documentation may not be requested or required as a barrier to entry. These documents do not convey any rights under the ADA. Documentation does not guarantee proper training or behavior. And the Department of Justice does not recognize any of these items as proof that an animal is a service animal, whether provided by the Michigan Department of Civil Rights or not. Service animals are legally defined and protected under the ADA by their disability test, training, and behavior in covered entities. And just some information about MDCR's voluntary ID program. So the Voluntary Service Animal Identification Program was created by state law. The program provides a free and voluntary service animal patch and ID card. Eligibility requirements and applications are available at michigan.gov/service animals, and you can check out the service animal FAQ at michigan.gov as well.
So moving on to some behavioral requirements, service animals must have sufficient behavioral training, often called public access training, to ensure that two things. The first and foremost, I think very important, is that they're housebroken. And second, that the animal has to be kept under the handler's control at all times. That means the animal has to be leashed, harnessed, or tethered at all times. And there's only two exceptions to that rule. The first one is that if the person's disability is such that it doesn't allow them to hold a leash, harness, or tether, or if the presence of a leash, harness, or tether would interfere with the work that the animal performs, the work or task. When can you remove a service animal? If a service animal, again, is not housebroken, if it's out of control, and then the handler doesn't take effective action immediately to bring the animal under control, the animal can be removed from the place of business. However, the handler or the individual with the disability should be allowed to remain in the business and given the opportunity to receive whatever goods or services that they came for without the presence of an animal. Service animals cannot be removed due to negative assumptions about how an animal might behave. We call that speculating on how an animal might behave without any real facts to back it up. A generalized fear of animals, because I know and we know that people do have a fear of animals. It could be based on something that happened to them before with an animal, and that's very common. But just because someone has a fear of animals doesn't mean that a service animal should be removed or not allowed to be in a place of business. And then finally, allergies. So if a clerk or the worker, someone in the place of business has allergies, the business is required to try to accommodate both individuals. So maybe having someone else service the customer or having that particular employee go to a different area of the business or building while the service animal is inside the building. If you do exclude the animal, there are some things you have to know. So service animals can be excluded if their presence would fundamentally alter the nature of a program, service, or activity, or if an undue financial or administrative burden would occur by having the animal there. So some examples of fundamental alteration, that just means having an animal in your business would so dramatically change the service that you provide that it wouldn't be reasonable to allow the animal. And the examples that we give, there are very few. So the examples that we give are an operating room, a burn unit. It would not be sterile to allow an animal in some types of settings like that. So it would change the nature of what service is provided, and so that animal would not be allowed. The ADA service animal rules don't override legitimate health and safety concerns, such as not bringing an animal into a swimming pool for the animal safety and then for the safety of others. Another example that we use is a zoo. There are some animals that are in zoo enclosures that a dog is their natural predator, and it can cause stress and anxiety in that zoo animal. And so that would not be appropriate to bring the service animal into certain enclosures. That doesn't mean that they are completely banned from the zoo. Everything with the ADA and disability rights laws are really a case-by-case basis. Banning a service animal. So again, a service animal can be banned from a business, but again, case-by-case basis, and it has to be based on actual behavior of that animal and not fear or speculation. Direct threats. Businesses are not required to provide access to people or service animals that pose a direct threat. And the definition of a direct threat is that it would result in a significant risk of harm to the health and safety of others that can't be eliminated by changing the way you do things or providing some type of auxiliary aid or service. Allegations of a safety risk must be based on facts. So again, case-by-case basis, you kind of have to go through and see what's the nature of the harm that would occur by allowing this person with a service animal in, what's the length of the time that that threat may exist. And then perceived threats without evidence to support it will never really be valid. So it's just important, if you think someone is a direct threat because they have a service animal, be prepared to be able to provide evidence to say why you think so. Information for businesses. So the handler is responsible for the care and supervision of that animal at all times. Businesses cannot assign people with service animals to specific rooms or tables due to their disability or because they have a service animal. You cannot segregate people out because of their disability, and they have to be provided goods and services in the most integrated setting. People with individuals are not required to pay extra fees for their service animal or any kind of deposit unless those same fees are charged to individuals without service animals or disabilities. They can be charged for damage that the animal causes, but again, only if you would charge other people damage costs for the damage that they incur. Service animal fraud. So false representation or registration of an unqualified or untrained service animal is a misdemeanor in our state. And a misdemeanor penalty could be one or more of the following: 90 days in jail, a $500 fine, community service up to 30 days, or any combination of those. And again, if you suspect reported service animal fraud, you report that to your local law enforcement agency. Our department does not handle complaints of service animal fraud. Some other laws just to be aware of as we move toward the end of our presentation. Public Act 144, again, it says it's a misdemeanor to harass or assault a service animal. And those misdemeanor penalties are what I just talked about. And it's just the general guidance of civil service animal law. Cannot impede someone who uses a service animal, cannot prevent them from coming into your business unless one of those things that we talked about earlier apply. Public Act 145, it talks about licensing fees for service animals. So if the county or municipality does have a licensing requirement for animals, dogs or cats, that does apply to service animals. They have to be licensed. However, the municipality would have to waive the fee. So they cannot charge a fee for the license of a service animal. Public Act 146 talks about what Anthony talked about earlier, is that our department administers a voluntary service animal identification program. It's free of charge. It's open to the public. If the individual meets the application requirements, what they can get is what Anthony showed earlier, is an identification card that looks similar to a driver's license and a patch to be affixed to the dog's harness, leash, or vest. It is not required under any state or federal law. In our state, our legislature deemed that it might be helpful for people with disabilities and service animals to have that ID program, and we administer that. And then finally, Public Act 147, again, it says misdemeanor to fraudulently hold yourself out as having a service animal or a service animal in training. I think that was yours, Anthony.
So if anybody has any questions for us, you can contact us at right here, Disability Rights and Compliance Division at the Michigan Department of Civil Rights. Our email is right here as far in the website. And for the Michigan Department of Civil Rights, our email is mdcr/info@michigan.gov, along with our phone number and as well as our website.
Thank you so much, Tyra and Anthony, for providing such informative information for Michigan businesses regarding accessibility. I would just like to remind our viewing audience once again that all presenters will be available for questions at the end of the program. Right now, we're going to continue our discussion on making Michigan accessible, but this time with a focus on digital accessibility, which is critically important in this current era. Please join me in welcoming Phil Deaton, who works as the Digital Information Accessibility Coordinator at the University of Michigan, where he works on digital accessibility compliance, including for the web, mobile apps, and beyond. Phil has previously worked at Michigan State University in a similar role. Phil is excited about working to increase digital accessibility in higher education and beyond, and is passionate about disability issues and culture. Phil, we are so glad to have you with us today and eager to hear your presentation.
This is Phil. Thank you, Tiara. So good morning, everyone, and thanks for taking the time this morning to think about accessibility and disability inclusion with us. As Tiara mentioned, my name is Phil Deaton. My pronouns are he, him, and I'm excited to talk with you today on making Michigan accessible. So you're definitely seeing some maize and blue, and you're probably thinking this guy works at the University of Michigan, and as Tiara mentioned, that's true. I work at U of M in our Equity, Civil Rights, and Title IX office. And I do focus exclusively on the topic we'll be chatting about today. So on this kind of stormy Thursday, I will be discussing digital accessibility and web accessibility. Don't worry about the U of M thing, by the way. I did my schooling at MSU, so I'm something of a neutral representative here. So Tiara, thanks for inviting me to the MDCR program. And if you could advance to the next slide. So there are a lot of ways to talk about digital accessibility and different areas where we could do a very, very deep dive. And you can do that into topics ranging from captioning to form design to web design, mobile app design. Today, I'm going to talk briefly about what digital accessibility is and why it matters. Then next, I'm going to talk about why you should care about digital accessibility. Third, I'm going to give some kind of practical tips for increasing accessibility of your services that are powered by web and digital platforms. And then last, I'm going to talk about some of the benefits of digital accessibility more broadly. I will briefly touch on expected forthcoming regulatory update, which is open to to public comment until October 3rd as well. And if you could please advance to the next slide. All right, so first up, what is digital accessibility? Go ahead and on to the next one, please. So I'm going to briefly read off the definition here and then talk about kind of functionally what a user's experience should be. So digital accessibility is the practice of ensuring that technology and digital content are usable by everyone, including people with disabilities, whether that person is using assistive technology or not. So really what this means is that a user can access your services, programs, and activities that are powered by technology, whether they have a disability, whether they do not have a disability, and whether they are also a person with a disability who uses assistive technology, such as a screen reader, which is a program which provides text-to-speech services and allows individuals to read web pages, to read content, etc. So really a goal that you should have with digital accessibility is that, you know, your application can be broadly used by people with and without disabilities, but also that it can work with assistive technology like screen magnifiers, like screen reading technologies. Generally, we find that in implementing more digitally accessibility practices, you're going to be increasing the usability for all of your customers. So for example, if you have a stronger color contrast, that will benefit people with certain forms of color blindness or who are low vision, but it will also benefit non-disabled customers and allow them to more easily get around your application or your service. So I think oftentimes disability exclusion in the digital accessibility context results not from direct bias, but just a lack of knowledge available for how to increase the accessibility of online services. So at the end of the day, the goal is to make sure that your website or digital application works for your consumer or your constituency. And you really want to make sure that people can complete tasks, buy your products, utilize your digital services. As Tiara mentioned when she was introducing me, I think this is particularly important as we saw with the pandemic, a lot of services adding a digital component in order to more easily reach customers and in order to more easily reach the general public. So if you can go ahead and advance to the next slide, please. I want to talk about some specific examples of how digital accessibility can come into play. So here's some kind of non-technical examples just to lead off with. Providing captioning for videos. Today we've got a live captioner providing captioning. Thank you. Additionally, you can add captioning to pre-recorded video content. So if you have a YouTube channel or are using some form of social media to connect with your customers, you can figure out, you can utilize methods to provide captioning in that video content. I used this example earlier, but making sure your text has strong contrast against your background colors. This is a practice that's a good design practice, but it's also a great accessibility practice. And there are some standards that I'll talk about in the how to meet digital accessibility section, which provide some guidance on what types of color contrast thresholds you should be meeting. And we will talk about that a little bit later. So using clear link names, instead of using a link that says, learn more and having that go to the umich.edu homepage, you could have a link which reads, learn more about the University of Michigan, or University of Michigan, homepage or something like that. These types of practices are really helpful for non-disabled users too, but for screen reader users who may be navigating by link on your website, this allows those users to understand what the destination of a link is so that they can more meaningfully engage with your content. So another practice around color. Avoid using color alone to emphasize or show meaning. So if you tell someone to select the green button to submit your payment, that may not be a viable way of telling someone with various forms of color blindness or who is fully blind how to utilize your service. Instead, using directions like the proximity of where the button is on the page or other methods of denoting difference and emphasis can be helpful. So here's one that I think can be particularly frustrating because we see so many good examples of this, but it's just identifying errors for users when they are trying to submit a form or doing a search. So if a user submits information incorrectly in a form or payment process, identifying where that field is that's in error. There's no more frustrating feeling for disabled customers and non-disabled customers than not knowing which field they made a slight mistake in when they're trying to access your program or service. So I know that some folks on the call may be a little bit more technical, so I did want to give a couple slightly more technical examples of digital accessibility. So one is alt text. This is a text alternative for images. So for example, if I had a graphic on this page, I could add an alt text attribute to it, which would describe the image within the context that it appears. So that within the context it appears part really means, there's a lot of elements to an image that you can describe. If I worked at one of UM's art galleries, I would probably describe an image differently if I used it in a PowerPoint than if I was just kind of alluding to some minor element of the image that I use to, just add a visual to my slide. So another area here is headings. So headings are really helpful on websites because folks with disabilities that are using a screen reader can navigate by headings. It does two things. It allows people to jump around your content quickly. It also allows people to understand how your content is structured. So you can do this on web pages. You can also do this in documents, such as Microsoft Word documents. Then my last technical example here, because I think this is particularly important because of all the ways we've added digital services the past few years here, is really making sure that you have form labels. So a lot of times forms will have visual labels, which to a sighted individual are, evidently describing a specific form field and what a user should enter into there. Sometimes folks that design forms don't have what we call a programmatic label. So there may not be a link between that visual text and the actual form field element. This is super frustrating for screen reader users because they may access a form and have no idea what a specific field, what they're supposed to enter into a specific field. So I really encourage folks that are kind of more on the technical side to think about that. Or if you're not on the technical side and you're just trying to think of or identify a WordPress extension or something, doing some basic searching on extensions and look for accessibility in the comments and in the features. Not all products include this type of thinking because digital accessibility is kind of more broadly entering public practice, I would say, although it has been around since web and digital has been around. If you can advance to the next slide. Okay, so why should you consider accessibility? Go ahead and advance. Okay, so I'm going to lead off with an essential, which is the legal part. But before I go into this, I am just going to give similar disclaimer to what Tyra gave. So I am also going to add that I am not a lawyer, so you should consider consulting one if you have concerns related to this area. But again, a lot of these, legal and regulatory frameworks revolve around a case-by-case basis. So really, you should consider consulting someone if you are, encountering a demand letter or someone who is asking you about digital accessibility in a way that concerns you. So, all right, fine print out of the way. So what are our legal obligations? So the Americans with Disabilities Act, Titles 2 and 3, which Tyra talked about today, do cover, are applied to digital contexts. So right now, they do not have very firm language around them, which specifically specifies practices that you need to meet in order to have a digitally accessible website, platform, or piece of content. I will talk about how that may be changing in the future, but I am going to go through some of these other elements. Section 504 of the U.S. Rehabilitation Act is also applied to public institutions. So if you're not a public institution, you may not need to worry about that as much, but there is an interesting interplay between the ADA, Title II, and Section 504. And then Section 1557 of the Affordable Care Act is something that you should think about if you are, providing technology to, medical facilities or hospitals, or if you are part of a medical facility or hospital. So there are actually various other laws in specific contexts, like the Air Carrier Access Act, which do provide some more guidance around digital accessibility, and which do create obligations for businesses and organizations around digital accessibility for people with disabilities. But I did just want to touch on those briefly. So on the horizon, there is a notice of proposed rulemaking for web and mobile app accessibility applying to Title II entities, which Tyra talked about in their presentation. I did want to note that federal agencies have long asserted rights for people with disabilities under the ADA apply to programs, services, and activities that are supported by technology. You can actually see letters to this effect from the DOJ and the Department of Education dating back to the late 90s. So I think it's an important thing to note here is that you really don't have to be a web developer or software engineer to think about this stuff. So this isn't just for folks that sell, web development services or create software. This is also for folks that are using technology to run their businesses, to interact with their customers, and to provide programs, services, and activities. So just calling back to Tyra's presentation again, we really want to make sure the overall service, program, and activity is accessible. And one of those proposed rules, the one I mentioned applying to public institutions, really introduces some complexity around offering, for example, a call service alternative for digital services that we have. So it discusses a different degree of agency, privacy, and availability that these services have as compared to a digital alternative. And I think that that's an important thing to think about as it applies to Title II entities, but also as you're thinking about digital accessibility for your business and your customers. So I think if you can advance to the next slide, there's a lot I could talk about there, but I think that's a good place to leave off for that one. So I think a core reason that you should really do this work is the more people who can use your site or your application, the more potential customers you'll be reaching, whether you sell products, services, or experiences, or a combination of those. Really, that's a great argument for thinking about this at all. The legal frameworks are interesting and important, and people do and have rights to digital products, applications, and services. And companies do have obligations around these areas. But really, I encourage you to think about the fact that the more broadly accessible your website is, the more potential customers you will be reaching. So if you can advance to the next slide. Okay, we're going to talk about how we do this stuff. So if you can go ahead one more. So when we talk about digital accessibility at University of Michigan, we talk about it kind of in two ways: being proactive with digital accessibility work and being responsive with digital accessibility work. I'm going to go into both of these concepts a little bit more deeply. And I'm also going to talk about some of the standards that are used and some practices that you could adopt today to increase your accessibility immediately. So proactive digital accessibility work. When you're building a new website, service, or offering products in a new way, leveraging technology, really thinking about how you can make that in an accessible way. So for folks that have something of a technical background or are going to be doing a lot of website development or app development themselves, I'm going to point you to the Web Content Accessibility Guidelines 2.1. So that's WCAG 2.1. So this is a standard which has a variety of success criteria, which are checkpoints that you should try to meet, that you should functionally try to meet throughout your product. So for example, I mentioned alt text earlier in a previous slide. One of the success criteria in WCAG 2.1 is 1.1.1, which is non-text content should have text alternatives. And one great way to meet that success criteria is by having alt text. So there are a variety of these different success criteria. Some of them are more difficult to explain than others to non-technical folks. But some of them are as simple as using clear link text. And then some of them are a little bit more complicated, like how you programmatically associate a form element to its label. But if you are really wanting to meet digital accessibility, that's the standard that you should strive for. There is another standard which is in development, which will be the Web Content Accessibility Guidelines 2.2. So that's just a 2.2 instead of a 2.1. But really that 2.1 is a internationally accepted standard, and a lot of organizations, for-profit, public institutions try to meet that standard. And if you're working with a supplier to design your website or your application, you should ask your supplier to meet the Web Content Accessibility Guidelines 2.1. And you can also ask them some follow-up questions about that, like how they train their staff in digital accessibility, what sorts of practices. There's a lot of important work that goes into being digitally accessible. Okay, so my second example for proactive accessibility is if you are not as technical, but you are using WordPress, Wix, or some other web content creation platform or content management system, you can actually usually search WordPress accessibility or Wix accessibility and learn more about these products. By the way, I'm just referencing these as two examples. This is not endorsement for either of these two products. So one thing that you can do in addition to searching about the accessibility of these platforms is WordPress, for example, has a way of searching for accessibility ready themes. And there are other similar tools in Wix. And what this will help you identify is themes that have been tagged as accessibility ready. This doesn't mean that they're going to be perfect, but this at least means that the person who developed that theme is familiar with what digital accessibility is and is trying to market this resource as digitally accessible. Okay, I want to step back from kind of the more technical stuff and the discussion around websites and applications to content development. And I mentioned this a little bit earlier, but it's also important to consider captioning video content and providing text alternatives for marketing materials. So this is a practice that you can add in as you are, creating your Instagram post, as you are adding your YouTube videos, really honing in on providing captioned video content and making sure that your customers can toggle that on and really connect with your message. So going back to proactive and responsive, I think it's very important to think about digital accessibility in both these contexts. It can be very difficult to meet every single standard of the Web Content Accessibility Guidelines 2.1. And so as you are working on meeting these standards and as you are improving your digital accessibility, you should really be responsive to customers that do have accessibility feedback. If a customer gives you feedback on accessibility, consider how you might make improvements to your site or e-commerce platform. Here at if we hear feedback on digital accessibility, we really try to focus in on addressing that concern specifically and making improvements to the website, in addition to making sure that the user has access to our program services and activities that website or application powers. I think that being both proactive and responsive, you're going to be able to best cover digital accessibility needs. So if you can go on to the next slide, please. All right, I want to talk a little bit more about the benefits of accessibility. And we've kind of considered this a bit, but I want to talk more broadly about this. If you can advance to the next slide. So there's three main benefits I have listed on the screen. If you're considering investing your time, energy, and expertise into this area, you're really going to be broadening your reach. I think that this is a great argument for why you should do digital accessibility work. If your site is more accessible, you will be reaching more customers, more respectfully, and in the ways they want to be reached. I include that last part because, again, that discussion around, is it okay to just have a phone call option? Sometimes customers want to be able to independently and privately access your service without engaging in a conversation. Had a really hard Friday and don't want to call pizza delivery service, you may want to just use the website or web application. So when you are meeting accessibility requirements around the Web Content Accessibility Guidelines 2.1, you're also meeting web and digital best practices. So you're really staying up to date with those practices. You're going to appear more highly in search engines, and you're going to be, putting your best foot forward when it comes to providing that exceptional user experience for your customers or constituents. And then the third reason, which I hope will be argument enough for this, is that you're going to be providing a more inclusive experience for your customers. If you're ensuring that customers with disabilities are prioritized as part of your business practices, customers with disabilities will notice this. Non-disabled customers who care about disability issues will also notice this. I think that this is a very important reason to do this work and a very important aspect of accessibility and disability inclusion practices generally. So if you can advance to the next slide. I want to talk a little bit about the inclusion piece a little bit more. So sometimes when we talk about inclusion, we hear words like diversity, equity, and inclusion. So I wanted to give a few notes here. First, I think it's important we don't consider accessibility without thinking about disability. This sounds really self-evident, but sometimes folks that are deeply interested in meeting digital accessibility standards, like that WCAG 2.1 standard, may get more interested in meeting the text of the standard rather than the person with a disability's experience. And again, going back to that proactive and responsive piece, we really need to proactively work toward these standards, but also we need to listen if there is someone with a disability that is unable to access a program, service, or activity that we are providing. So I think that that's really important to consider. So compliance is often the focus of accessibility work. I do think that there are some pitfalls to that focus. Sometimes if we're focusing in, again, on that compliance piece, we're going to be missing opportunities to really communicate how we are prioritizing customers with disabilities and constituents with disabilities in our business. And I think that you're not going to be able to tell the full story of why you're interested in this work in the first place. So disability is really part of diversity, and I think it's important to include accessibility in conversations around disability, equity, inclusion, and justice. And again, really broaden that idea of accessibility beyond compliance piece and beyond that meeting individual specific access needs piece to thinking about accessibility as a core practice that is part of our businesses and part of our organizations. I think that's how we're going to really push for more digitally accessible public entities, businesses, and more. Okay, so if you want to go ahead and go to the next slide. I did touch on this briefly earlier, but there is a new notice of proposed rulemaking in the Federal Register, which is available in digital format. And the new notice of proposed rulemaking is around web and mobile accessibility in state and local government entities and public institutions. I wanted to mention this because this is actually open for comment until October 3rd. So if digital accessibility is something that's important to you or confusing to you, you may want to either comment on this NPRM or read a summary about it. The ada.gov site actually has a pretty nice summary, and it's a compact summary of what is a long document, which kind of goes into why the Department of Justice and others believe that this is an essential update to our regulatory environment. So an important thing to note, Tyra talked about Titles 2 and 3 of the ADA. this would be primarily applying in that Title II context as it is currently written. I will also just include that if you are the type of person that really likes deep diving into these things and learning about these types of proposals, the document is quite long because there is a preliminary regulatory impact analysis, which discusses a lot of expected costs and benefits to society. So anyway, I guess if this is something that's of interest to you or a topic that's of interest to you, I really encourage you to check out that NPRM or check out a summary of it. And if you can go ahead and advance to the next slide. I just wanted to say thank you, Tierra, for inviting me to join the presenter team today and for coordinating a lot of the work around this program. And also thanks to the MDCR team for helping to screen share. And also thanks to everyone for taking time out of this waterlogged Thursday to really think about accessibility. So if you want to go to the next slide, actually, I'll turn it right back over to Tierra at this point.
Thank you so much, Bill. Thank you. Thank you for your presentation. You have given us a lot to consider regarding digital accessibility, which I'm sure was very helpful for our viewers who likely have questions for both you and our other presenters today. So we are going to move right into our question and answer portion of the program. Again, participants are free to pose questions using the Q&A function on the lower part of the screen. I'm now going to ask all of our presenters to turn on your cameras, and we will begin taking questions. So this is Tierra speaking. To start, I want to say, Phil, I love that during your presentation, you said that accessibility is something that everyone should consider regardless of their role at a business or organization. I know when Tyra and Anthony were presenting, they talked a lot about businesses' legal obligation to provide goods and services that are accessible to all. And then you also touched on the impact that accessibility can have on a business's brand reputation and even their bottom line. I'm wondering if any of you have any more to say about that.
This is Phil. I hope that legal reasons will, entice people to learn more about this. And I also think that DEI, diversity, equity, inclusion reasons should be considered. But I really think that businesses that are considering investing in this, whether they're small or mid-size, should really think about that bottom line piece too. If you have more customers that are able to interact with your website or order products from your application, you're going to be able to connect with more people. I don't have too much more to say about it other than I think all of these are good reasons to do this work, but really hope you think about the disability inclusion reason in all of them too.
Thank you, Phil. All right, so I am gonna ask of Tyra, are you able to talk to us a little bit about what discrimination might look like at Michigan businesses for persons with disabilities?
Sure, this is Tyra speaking. So just a little bit of my background. I started with the department a long time ago, and I was an investigator, a staff attorney, and now in this position. So I've seen firsthand from taking, complaints against businesses, what discrimination can look like. So it can mean a lot of things. Very particular examples I can give. Persons who use mobility devices. So a lot of times we've seen that in a business, there's a misconception that, or maybe it's happened one time, that mobility devices cause damage to a building. So relegating persons who use mobility devices to certain areas of a business or a store, or not allowing them in at all. That could be one thing that we've seen. A daycare center who refuses to admit a child because maybe someone in the family has a disease. And to be very honest, we've seen this with diseases that are stereotypically considered to be bad, like HIV or things like that. Even though that child seeking admission may not have a disability, because there is associational protections for people with disabilities as well. A restaurant who may refuse to serve customers because that customer has filed an ADA complaint or a disability related complaint against the restaurant for not being accessible in terms of access to the restaurant. Buildings that have multi-stories to them, and there's an elevator in the business, and the owner or manager decides to turn off the elevator during certain portions of the day to save money or energy, when that elevator is the only means of access for a person with a specific types of disability to move throughout the business. I could go on and on, but those are some examples of what it may look like. If someone requires an interpreter, whether it's American Sign Language, other sign language variations to communicate in certain aspects of the business, whether it's a doctor's office. We see those heightened stakeholders where it's a doctor's office, court system, attorney's office, that type of thing, where the doctor or hospital may say, we can't afford that, or we don't do that. That's a big area of concern, because there are obligations under state and federal law to provide those things, which we said are called auxiliary aids and services.
This is Tiara speaking. Thank you so much, Tyra, for that. We do have a question from one of our audience members. I'm going to read it. It says approximately 30% of our population has some degree of reactions to fragrances, from sneezing to stroke. With healthcare using fragrances in their cleaning products and fragrance emitting devices in their spaces, healthcare has become completely inaccessible to people with fragrance reactive disabilities. This is a violation of the ADA and state law, as reactions to fragrances cause definitional disability, and healthcare is a critically necessary service. How do we address this problem through state law to require healthcare settings to be fragrance-free at baseline for equal access? For clarity, I am speaking of the things that are 100% within their control. And I will throw that question over to Tyra.
So this is Tyra speaking. So we know that there are many studies, especially I think 2 specific studies, that we know 30% of people report having some type of sensitivity to scents worn by others. And some of those practices that may be acceptable outside of hospitals are not necessarily inside, and that's one of those areas. The Title III of the ADA applies to businesses that are open to the public. As Phil said earlier, Section 504 of the Rehabilitation Act applies to any entity that receives federal funds. The ADA is another federal law that applies to, Michigan Persons with Disabilities Civil Rights Act is our state law, ADA is the federal law, and then 504. So there are laws that say that you have to accommodate persons with disabilities. And if a chemical sensitivity rises to the level of a disability, they certainly have to accommodate that. Does that always happen? I know in reality that it doesn't, because even though many hospitals do have fragrance-free policies, many don't, and many don't enforce them. So it is an existing issue, and to get that codified or included into a state or federal law specifically would require some lobbying at the state or federal level to do that.
This is Tiara speaking. Thank you, Tyra. We have another question from one of our audience members. The question is regarding visual effect. Are there specific color combinations that are preferred? And Phil, I will defer to you.
Thanks, Tiara. So this is Phil speaking. There are some specific combinations that you may want to focus in on. So I'll give some broad strokes guidance. In general, if you have a darker background, you're going to be wanting to use a lighter text color. And if the inverse is also true, if you have a light background, you may want to use a darker text color. There are some colors which are harder to make accessible per the color contrast requirements. But there are a lot of tools out there where you can kind of just plug in the color that you've got, whether that's the hex code or the RGB, and figure out an accessible color that augments that. So one thing web designers do frequently when they're designing a new platform is create a color palette. And if you're in the practice of web design, you may just want to make sure that your color palette combinations work with each other. Here at UM, we have, branded University of Michigan colors like that maize and blue that you recognize, as part of our brand. And one thing that we've done is we've made it available to our marketing and communications professionals which ones work in accessible combinations, and we provided kind of recommendations that work there. You can actually find that on our brand website, which is publicly findable. But yeah, my general guidance would just be that light on dark, dark on light. And if you are unsure based on your personal discernment, or if you have a form of color blindness or low vision or fully blind and don't know how to make that, cannot make that discernment yourself, you would definitely want to use a color contrast analysis tool. And again, you can kind of just search color contrast analyzer, but there are some which are desktop applications that you can download, a lot of free open source ones in the digital accessibility community. And there's also some which are just a web page which you plug your colors into. And a good resource for that is the Web Accessibility in Mind WebAIM website. Has a color contrast checker where you don't need to download anything. You just plug in the color for your foreground text color and your background color. So sorry, that's a little bit of a roundabout answer. I will say one color that can be challenging to make accessible if you use it as a text color or a background color is certain forms of orange. But again, it's just kind of individually dependent upon the colors you're picking, and it's just incumbent on you to do a quick check to see if it will pass the Web Content Accessibility Guidelines 2.1 standards for color contrast.
This is Tiara speaking. Thank you, Phil. We also have a request for you to share your email address. I'm not sure if that's something that you are comfortable with. If so, do you mind verbalizing it right here for
Sure.
us?
I am at pdeaton@umich.edu. So that's PDEATON@umich.edu. Feel free to reach out to me with your question. Thank you.
This is Tiara speaking. Thank you, Phil. We do have another question. Do businesses have the autonomy to be reactive, or are they expected to be proactive when it comes to ADA compliance? For example, can accommodations be made once an employee is hired, or is it the expectation that the building, equipment, et cetera, be in compliance already?
This is Tyra. Do you want me to take that?
Sure, Tyra.
Okay, so you're kind of mixing some things there. So we're not really talking about employment today. We're talking about Title III, which are businesses that are open to the public. But I mean, and we're also talking about different things. So if you're talking about physical accessibility with new construction or alteration of existing buildings, you have to be proactive. You have to be in compliance before someone comes into your building and says, I mean, does that happen all the time? Let's be real, right? We know that there are many businesses that are not in, and there's many reasons. But so if we're talking about physical accessibility, we're talking about bricks and mortar accessibility and construction. There are two different standards, two different applicable standards for Title III. There's the 1991 standards and the 2010, and it really depends on when the building was constructed. But for existing buildings, not new or alterations, the obligation for a business is to provide access or to remove barriers and the standard is if it's readily achievable. And what that means is with little difficulty or expense. So there is that requirement to be proactive and to take those steps to remove barriers if it's readily achievable. Also, depending upon when the building is built, you have to be in compliance with the applicable standards. When it comes to the individual coming into the store or business or even the employer and asking for accommodations that are very personalized and particular to them, there is no obligation for the employer to be proactive to have things ready to go, because it really is tied to a case-by-case basis and what that person needs. Because we know there could be 10 people with the same diagnosis, but it affects them all differently. So while the employer has to make changes to the rules, policies, and practices or the business to allow that person with a disability to engage, you can't speculate on that, and you can't offer an accommodation unless one's been asked for. So it's kind of like a yes and no on both. You have to be able to say that we are in compliance with design and construction standards, the removal of barriers if it's readily achievable, but then also be tied into the individual's needs when they request a change of to a rule, policy, or practice.
This is Tiara speaking. Thank you, Tyra. We do also have a somewhat of a question in the Q&A function here. It says, will you talk to the ADA Center of Michigan, Great Lakes ADA Center, Dan Cooper at Disability Rights, and MAPAS? I'm not quite sure that I understand the question. So if that audience member can maybe provide some clarity for us, we'll be glad to answer that. But I will say that the Michigan Department of Civil Rights partners with lots of other civil rights organizations and people dedicated to diversity, equity, and inclusion. We work collaboratively with many partners. My next question is, what are the ramifications for businesses who fail to ensure that their goods and services are accessible to all?
This is I almost said this is Tiara. This is Tyra. I can take that, and then Phil, if he wants to address the digital. I mean, I think there's a lot of overlap, but as Phil talked about, it's the law, right? We all know this is the law, and there are monetary. There are things that can happen as far as private lawsuits. Individuals under the ADA and state law can file private lawsuits without going through an administrative process, such as filing with our department first. The Department of Justice can get involved and do an investigation and then file on behalf of, if it's a pattern and practice, they can file a lawsuit or an investigation and then a lawsuit against a class of persons. People can file with our department, they can file on their own, but more importantly, there can be a loss of goodwill with a disability community, a community that's already been marginalized throughout the history of our country, and loss of business. Like Phil mentioned earlier, if you're limiting your class of customers, your pool of customers, you're really hurting yourself, because people with disabilities, just like everybody else, they buy things, they engage in commerce. That's the whole purpose of the ADA, right? Is to make sure that everyone has equitable access to these things. So not only are there legal complications and loss of money, but it's really like the right thing to do. As I said earlier, this is the one protected class, right, that any of us can become a member of at any time in our life. So we all know somebody who's a person with a disability, whether it's ourselves, a friend, a family member, coworker, and it's just the right thing to do, because we can all find ourselves there someday.
This is Tiara speaking. Thank you, Tyra. Phil or Anthony, would you like to add to that at all?
This is Phil speaking. All the reasons that Tyra gave are really excellent reasons. Depending on the type of organization you are, you may have different regulating agencies which you may have to engage and interact with to resolve accessibility issues. And I think that, just if you're focused on doing this proactively, then you can focus on disability, inclusion, and accessibility in the ways that you know are best for your business. And again, connecting back to that bottom line, that brand piece. Whereas if you're responding to a lawsuit, a demand letter, or some kind of regulatory action, then you may have to kind of fit into that model. So I really encourage that proactive piece. And again, being responsive when you do hear feedback is, I think, really important too.
This is Tiara speaking. Thank you. Phil, I will pose this question to you. If a business wants more in-depth training on digital accessibility for their business or organization, where can they go?
This is Phil speaking. There's a lot of organizations, including consulting agencies and such, that can provide information on digital accessibility. One thing I will say is that the digital accessibility community overlaps a great deal with open source software communities and open educational resources. So there's a lot of free stuff out there is the point that I would lead with. So the Web Content Accessibility Guidelines 2.1 has a lot of information about how to meet standards, what types of web technology solutions may meet a standard best. So if you're super technical, I'd start there. If you're not super technical, there are resources like WebAIM, which is a nonprofit attached to University of Utah, I believe, which does have a lot of articles and resources on accessibility that are really written and directed to meet less technical audiences as well as a little bit more technical. The resources kind of curve up and will help you get your skills up. So those are places I would direct folks to. And I think, if you are wanting to make a kind of more substantial investment in this area, you could look into the various consulting agencies that do this work, but I can't recommend or endorse any of them. So you'll have to do that research on your own. And I guess a final part I would mention is there are a lot of free virtual conferences on digital accessibility. And you can find a lot of stuff by Googling, YouTube, or just kind of using your favorite search engine or machine learning, generative AI, whatever you want to use, to kind of look into, if you're building a WordPress site, WordPress accessibility. And you can usually find information because there's a lot of people that are in this field now. It used to be smaller, but it's a very big and vibrant public discourse now.
This is Tiara speaking. Thank you, Phil. We do have another question from one of our attendees. They're asking if each presenter's contact information and PowerPoint will be made available to them.
This is Tyra. Our PowerPoint, I did notice a little error on ours before we started, so I changed it so we can provide that. And our contact information is on the last slide, so we can certainly get that to Tiara and she can send that out to the calendar invites.
Thank you. Also, I do want to note for our viewing audience that this session will be available for replay on the Michigan Department of Civil Rights YouTube page. So you will be able to go back and reference it at your convenience. We'll ask one more question. This question will be for Tyra and Anthony. If there is a customer at a Michigan business that finds that the goods and services of that business are inaccessible, what can they do?
Sure, this is Tyra speaking. So there are avenues, right? First thing you could do, and Phil can talk about this too. You can contact our department, right? And we can, that's part of what we do. The Michigan Department of Civil Rights has many divisions and units. We have an enforcement division that handles those administrative complaints that people can file under our state law. And here, if it's a business that's open to the public and it's a disability concern, we have jurisdiction under our state law only. The Michigan Persons with Disabilities Civil Rights Act. And again, it mirrors the ADA and some of the protections. So they could contact our enforcement unit, talk about their rights and obligations and see if it's something that they, if it's timely and jurisdictional, if they want to file a complaint. They can also call our division, the Disability Rights and Compliance, ADA. If they want to learn more about their rights, we can talk about that too, and we can point them in the direction of other resources as well. And Phil can speak to, resources as far as the work that he does.
Thanks, Tyra. This is Phil speaking. There's a lot of avenues, as Tyra mentioned. Large organizations probably will have someone that's familiar with this topic and can maybe help you navigate these issues or report these issues. As Tyra mentioned earlier, you don't necessarily have an obligation to follow that practice, but if you're really wanting to get that quickly addressed, that could be an option in front of you. For example, University of Michigan has a couple offices dedicated to this. We have the Student Accessibility and Accommodations Services Office, which helps serve students with disabilities in a variety of ways. We have an office within our Information and Technology Services division, which is dedicated to this. And we also have my office, which is the Equity, Civil Rights, and Title IX office, where you can report compliance concerns, barrier reports, all of that kind of stuff. So yeah, there's a lot of options open to you.
This is Tiara speaking. Thank you all for that. At this time, we do not have any more questions. And so we are going to wrap up the program. As we close, I would like to extend major thanks to all of our panelists. Your expertise and insights have been invaluable. I would also like to thank our registered participants and those who have viewed via live stream. We welcome you to join us as we close out this year's campaign at our annual My Response to Hate conference, which is scheduled for Thursday, September 14th from 8 a.m. until 3 p.m. at the Kellogg Center in Lansing. This year's theme is Legislating Against Hate, and we have an amazing program lined up for you. Registration is limited and is filling up fast. To find registration information and to learn more about the My Response to Hate campaign, please visit the Michigan Department of Civil Rights website at www.michigan.gov/MDCR. We hope to see you at the conference next month and at the launch of our 2024 virtual campaign series in January. Remember that eliminating hate and bias in our state is all of our responsibility, and we thank you again for joining us today.